Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases, laws, and topics affecting New York City tenants. I am Michelle Itkowitz, and today we are discussing Easter Home LLC versus PAL Partners LLC, a recent case out of the New York City Civil Court that helps us interpret a fairly recent change in the law that will allow tenants to redeem their residential tenancies for less money if they find themselves facing eviction. First, let's set the stage with some context. An eviction case based on non-payment of rent in New York State goes like this. Let us say you get sued in housing court for non-payment of rent. And let's say, God forbid, after a trial or a motion, you lose the case. And now there's a money judgment against you and a judgment of possession against you. At that moment, you're not evicted. Just because you lost the case today does not mean you're evicted today. The landlord has more to do if it wants to evict you. The landlord needs to apply via the clerk of the court for what's known as a warrant of eviction. That's a piece of paper. It's the piece of paper that allows a marshal to be able to carry out the eviction. But this process of obtaining the warrant of eviction, that takes time. Right now, I estimate it takes about 6 weeks, depending on the borough. But even when the warrant of eviction issues from the clerk's office, at the moment that piece of paper is created, just because the warrant exists, you're still not evicted. The landlord has more to do if it wants you out. The landlord needs to request that a New York City marshal serve you with the proper statutorily required 14-day notice and then schedule the eviction. And it can't be scheduled before the 14-day notice period is up. It usually takes longer than that to get a date. So even when the eviction has been scheduled, until the eviction happens, you're not evicted. You're not evicted until you are evicted. And that's important because until you're evicted in New York, the law gives you something called the right of redemption. It's governed by Real Property Actions and Proceedings Law, Section 749(3). That's the statute implicated in today's case. And it says that the court shall vacate a warrant upon tender or deposit with the court of the full rent due at any time prior to the execution of the warrant. Let's go over that again. The court is going to vacate the warrant. So the case against you is basically going to go away if you pay the full amount due. But a question arises because remember, I was just telling you about there's different stages. There's the date you get a judgment, and that judgment is for a certain dollar amount. And then there's the date that the warrant issues from the clerk, and then there's the date that your eviction is scheduled. And as these dates progress, and maybe they're weeks and months apart, you might owe more and more money. So exactly what does it mean to pay the full rent due? Is the full rent due the judgment amount or the amount due on the day you're scheduled to be evicted? What is it? I made up an example. Let's go through the example. Let's say the rent for your apartment's $5,000 a month. I made up that number because it's just easy to work with mathematically in an example. So let's say you owe 2 months of rent on February 1st. So you owe $10,000 when the landlord sues you. And you go through the housing court case, and on April 1st, the court enters a money judgment against you. But by then, you owe 4 months of rent, so the judgment is for $20,000. And then it takes a while to get the warrant of eviction out of the clerk's office these days. So let's say on June 1st, the warrant of eviction is issued and you still haven't paid any rent. Now it's 6 months at $5,000 a month, you owe $30,000. And then for whatever reason, maybe you start negotiating with the landlord, maybe the landlord isn't paying attention, whatever it is, your eviction then isn't scheduled until, let's say, early August. So now another 2 months have come due, 8 months, and so you owe $40,000. You decide you have some money aside, you borrowed some money, whatever it was, you want to redeem the tenancy. You decide you want to put this train back on the track. So you run into court with an order to show cause, that's an emergency application, to ask the court to allow you to pay the full rent due, as the statute says, and block your eviction. And you have $30,000. And you say, well, this is the amount that was due when the warrant was issued. And the landlord says, no, 30,000 isn't going to do it. That tenant needs to pay 40,000 because that's what's due through today. That's what paying the rent in full means. Well, who is right? And that's what today's case answers. And it's answering something that's an issue of first impression. At least that's how it appears to me, because this statute was changed with the Housing Stability and Tenant Protection Act of 2019. Now, I know that's 5 years ago, but we've had the pandemic and the courts have been slow. So now we finally have a case interpreting the new language in the statute that's going to help us understand what paying the full rent due to get the warrant vacated, what does that mean? So now let's get into today's case and get our answer. Okay, let's get into today's case. In today's case, the tenant lost, and there was a money judgment against the tenant through September 2023 for $10,656, and a judgment of possession came with that. The warrant wasn't issued until, it looks like 3 months later, in January 2024, when the tenant owed $28,621. And then the eviction wasn't scheduled until March 2024, when the tenant owed $37,950. So the tenant ran into court and said, I want to pay everything. Here I have $28,000. I want the court to vacate the warrant. And the landlord said, no. The full rent due is $37,000 through today. Well, the court looked at the new additions to the Real Property Actions and Proceedings Law 749, put there by the historic Housing Stability and Tenant Protection Act of 2019, which added the language that says, what is the amount of the full rent due that is supposed to be paid? The court looked at this language. It's to the time when the warrant was issued. To the time when the warrant was issued. So the court went with the $28,000 that was due in January when the warrant was issued from the clerk's office. The court did not require the tenant to pay the extra $10,000 in rent that came due between the issuance of the warrant in January and the scheduled eviction of the warrant in March. So 28 versus 38. That made the landlord very unhappy. I checked in the court file and the landlord appealed. The appeal was never completed, however, and never will be, because the parties settled in some kind of out-of-court settlement. But this brings up some very important tenant takeaways. First, let's get the housekeeping out of the way. This isn't legal advice, and I am not your lawyer. But because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it's terrible, because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. If you deem this work worthy, please bestow upon us the 5 stars and do us the honor of subscribing. You can certainly use this podcast by only listening to the episodes that you believe apply to you. However, a lot of times we're answering the questions that you may not have even known that you had. With every average 12-minute episode, you increase your literacy about the most important issue in New York City today, housing. It's time for the tenant takeaway. Tenant takeaway time. Often during the pendency of a non-payment case in housing court, tenants are biding their time, hoping to negotiate or litigate the number that they owe down while simultaneously trying to collect the money they do owe, either by saving it or borrowing it or getting it from the city or a charity. Also, during the pendency of a non-payment case in housing court, tenants are often trying to make decisions. Do I redeem this tenancy before I get evicted, or do I start fresh somewhere else and hope the landlord does not chase me to collect the money judgment? That's a process people are often going through. So when the wolf of the marshal is at the door, the number required to redeem the tenancy and make the whole thing go away, that number being lower rather than higher can make a huge difference in people's lives. If you had asked me last year about this, I would have said that even though this case and the statute are not specifically about rent stabilization, that all of this applies really more to rent stabilized tenants, because rent stabilized tenants, if they can weather a period where they fall behind on the rent and get back on track, then they may be able to stay in that apartment for the rest of their lives, unless the landlord has one of the very few grounds left available to evict rent stabilized tenants other than non-payment of rent. So the right to redeem and redeem for less money rather than more money is something that is always going to be vital to rent stabilized tenants. But this year, 2024, as of April, we now have good cause eviction. I estimate, and this is just my estimation, it's not scientific, I estimate that good cause eviction is covering at least 500,000 apartments, which before April 2024 were free market. Good cause eviction is not as beneficial to tenants as rent stabilization, but it still provides a check on how much the rent can go up and protection from eviction for all but a narrow list of good causes. To learn more about good cause eviction, by the way, go back and listen to shows 25, 26, 27, and 29. 25 and 26 especially, because 25 explains what good cause eviction is and 26 explains who it applies to. The point is, if you have a tenancy protected by a statute, so your rent increases are limited by that statute, and you can only be evicted for a narrow list of good causes, you have a tenancy that very well may be worth protecting. And in that case, a statute like this and a case interpreting it can be the difference between you saving the tenancy and losing the tenancy. If the number required to redeem the tenancy is lower rather than higher, that can make a huge difference in people's lives. So keep this one on your radar. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.